All you need is that red light in front of you, right? To know that you're live. They haven't figured that out yet.
Yeah, right.
I see one up in the corner that says we're recording, but. So I think we're right about the 9 a.m. mark, but we'll wait another minute
Couple
and
minutes. Okay.
allow folks to get situated. Get their coffee safely in front of their laptop. So for those of you who have registered for today's seminar, we'll be getting started here momentarily. I want to wish everyone a good morning here. My name is Carlos Rodriguez. I serve as the Executive Officer for the Building Industry Association, Southern California's Baldy chapter. I want to thank you all for registering for our Mechanic Liens Claims Seminar, Advanced Mechanic Liens Seminar. And again, it's part of the BIA Southern California's mission to provide a variety of education services as part of our mission. To provide not only education for our over 1,100 members across Southern California, but also to provide advocacy for the home building industry and construction industry at large. The BI Southern California Baldy chapter is one of 4 chapters throughout Southern California, including San Bernardino County, Riverside County, Orange County, LA, and Ventura counties. And this morning, I'm delighted to have a friend of the industry and certainly of the BI Baldy chapter, and Teresa Crawford Tate with Crawford and Bangs, and she'll be providing today's seminar as she's done for many years. We're so grateful for the partnership with you, Teresa, and with Crawford and Bangs, and thank you. And in the midst of the pandemic, new platform, but same outstanding information to help the businesses be able to be equipped and ready to deal with situations that come up. To utilize this information. So with that, I want to thank you, certainly Teresa and Crawford and Bangs, and all of our registrants today. If there's information that you need about the BIA, feel free to go to biabuild.com. That's www.biabuild.com. And again, my name is Carlos Rodriguez, and I'm just a call away as well if you ever need any assistance. We'll hand it over to you, Teresa. Thank you.
Okay, thank you, Carlos, for the great introduction, and good morning, everyone. My name is Teresa Tate. I am one of the law partners here at Crawford and Bangs. We're construction attorneys, so all we do is construction, from suppliers, subcontractors, general contractors, and developers. So we represent everybody in the chain. I've been doing this since 1992, so quite a few years now. This is the advanced mechanics lien, but all that means is we focus more on the stop notice and the payment bond claims, which we don't cover very much in the basic mechanics lien, where we focus on the preliminary notice and the mechanics lien itself. But we will go through the preliminary notice, the mechanics lien, as well as the stop payment notice and the payment bond claim. So we will get started. I'm going to get rid of my video so that you could just hear me. We have posted, or I have posted in the chat box, a Dropbox that has all the materials for this morning. There's the forms, there's the PowerPoint, some outlines that we prepared on these mechanics lien topics, all in, and you should be able to see it if you go to the chat. The way we're going to run this morning is I tend to take a break every hour. So about 10 o'clock and about 11 o'clock, we'll take a break. And when we come back from break, I'll go through the questions. So you can post those for me in the Q&A box or the chat box. Either is fine. And I'll answer the questions so we don't get too far along while your questions are pending. But that way I don't have to stop. When I used to do these classes in person over at Baldy View, it was easy for people to just kind of show me that they had a question, raise their hand, whatever. So it's a little bit different in this format, but we're still going to give you the exact same information, go through all of the mechanics lien claims for you this morning. So, so you have an idea by what we mean by mechanics lien claims. Let's see if my screen will advance. Okay. There we go. Types of lien claims. So we have various claims on, depending on what type of project you're working on. So if you're working on a private project, you have a mechanics lien itself, you have the stop payment notice, and you have potentially a private work payment bond. If you're on a public works project, you only have a stop notice claim or a public works bond. On your federal projects, you've got the Miller Act bond, which is very similar to our California payment and performance bonds. And then when we're working on Indian reservations, we have no lien rights. So we need to be aware of that. And we call all of these mechanics lien claims because they come out of the mechanics lien statutes. But there is a particular form, a mechanics lien, that we can record on private projects. But the stop payment notice is a similar remedy, stopping the money instead of putting a lien on someone's real property. And then the bonds is where we go after some type of security that's put in place to pay all of the claimants on the project. So all three of those types of claims are what we're going to go through this morning. Then we're also going to touch on your releases, your statutory release forms, your prompt payment penalties, because those arise out of the mechanics lien statutes also. And as we go through, I'll deal with both legislation and then some case law that's defined or particularized how we should deal with these types of claims. So we talk about a lot in the basics. The whole point of doing this is to get people paid. If you're on the supplier, subcontractor, general contractor side, if you're on the owner side, the point of knowing all these things is to make sure that your project is not hit with these claims. To the best of your ability, you can protect it or watch out for the preliminary notices, the get your releases, and all of that. So both have a role, and I'll talk about both those roles as we go through this morning. So hopefully you've been to a seminar, or maybe this is all completely new to you, but we changed all the mechanics lien laws on July 1st, 2012. So if you were used to the old statutes or you had any of our old mechanics lien books, we referred, those were in the 3000 section. Now our private works has been moved to 8,000 and the public works to 9,000. So all of the forms, and it's helpful to know these numbers, because when you pull up a preliminary notice form or a mechanics lien form or a stop payment notice form, they should refer to statutes that are in the 8,000 or the 9,000s, and that's on your releases also. So if you're seeing those old 3,000 numbers, you might have an old form, so be very careful. The numbers can help tell you if you have an updated form. All of the forms that we're going to go through this morning are on our website. They're in the Dropbox that I put the link in the chat box for you. But they're also free on our website at builderslaw.com. We keep them up to date as the laws change, as the case law comes out, to make sure you can get the most current forms. So we've had people using 10-year-old forms, and it could definitely impinge your ability to be paid if you're using one of those old forms. So make sure you got the latest forms. We changed the forms for the conditional and unconditional releases, the preliminary notice, the mechanics lien, stop notice, all of your releases of your stop payment notice and your mechanics lien. So the first thing we're going to talk about this morning is your preliminary notices. So in order to have a mechanics lien claim, a stop payment notice, a payment bond claim, the first place we start is with our preliminary notice. If we don't do a preliminary notice, then we potentially do not have one of these claims. So the first thing out of the chute we need to get familiar with and get used to doing on all projects over $500, you're supposed to do a preliminary notice. So you do, but different companies set different levels. Some only do them if the job's over $1,000 or $2,000. That's a company decision on when you serve that preliminary notice. But if you want to have a mechanics lien, a stop notice, or a payment bond claim, you got to let that owner know who you are. It's to give everybody notice. So preliminary, generally before I start work or at the time I'm starting work, hey, I'm on the job, and here's the work I'm going to be doing. So that preliminary notice should be served within 20 days of providing the first labor or materials to the project. You can serve it late. If you find out, oops, we signed a contract and we actually had materials delivered or we started working, but we haven't served our prelim, we can go ahead and do that. It'll go back 20 days. So it'll only cover the last 20 days of work that we've done on the job, but I generally find that projects tend to run out of money towards the end. So luckily the work at the beginning is the most likely to be paid. So if you find out you haven't done it, go ahead and serve that preliminary notice. Or as soon as you set up your contract and you know you have a firm commitment to do the work, even if you're not going to be starting for quite a while, go ahead and serve the preliminary notice. You can't serve it too early as long as you have a commitment to do the work. You don't have to serve a preliminary notice if you're in one of these situations. You're a laborer working for wages. So employees have mechanics lien, stop notice, and payment bond rights without ever serving a preliminary notice, and that's because employees are a protected class in California. So they don't have to do one and they can still have a claim. If you're a direct contractor, and by that I mean you're working directly for the owner, is what we call the direct contractor. So usually the general contractor, or I refer to them as prime contractors. So the person who's in first position, if there's no lender on the project, then you don't need to serve a preliminary notice. If there is a lender, then even the direct contractor needs to serve the preliminary notice. On public works, the first tier subcontractors are not required to serve a preliminary notice, but I suggest that they do it anyway. So if you are a subcontractor of any tier, on whether it be private or public, you should serve the preliminary notice. The point is you want people to know you're on their job, and that way they can protect you. They can make sure that you're paid. When I do these classes for BIA, when we used to do them in person, the owners would send people from their accounting department, and the preliminary notice is important to them. They want to know who the subs are. They want to make sure they're getting the releases and that people are being paid on their project. So serve the preliminary notice, even if for some reason you're excused. And then potentially if it's a payment bond claim we have and we didn't serve the preliminary notice, or there was something wrong with our preliminary notice, we have a backup form called a notice to surety and contractor, and we can serve that at a certain time after we've finished our work. And we'll get to that when we get to the surety bonds, but it's a escape if we didn't do our preliminary notice, and we should have done a preliminary notice. So the direct contractor is the person who's obligated to make available to any person seeking to give a preliminary notice the name and address of the owner and the name and address of the construction lender. And this is provided for in the civil code. So if you have someone who's being difficult, not sharing the information, then you can let the direct contractor know, we're entitled to this information under the civil code 8208. So that we can serve our preliminary notice. We have a right to do that. If the direct contractor doesn't share Well, you're not excused from giving the preliminary notice. Sometimes people will call and say, well, we just couldn't get the information. We asked and we asked, so we didn't serve the preliminary notice. We can't do that. We have to go somewhat beyond. We have to do our due diligence if we're not given information. So we use lotbook.com. It's a $20 or something fee to get to find out who the title owner is of the real property. They can also find the lender for you if it's in title. You can use some other trade associations. If you got a good connection at a title company, they're very helpful. They can find this information for you too. A lot of the county recorders are on websites now, so it's easier today than it ever has been to find out this information that you need to serve the preliminary notice. So we got to do some investigation. We got to find out who we put on the form, because this form has to be served on the owner, the lender, and the direct contractor. So we need to find out who those people are. If we get information, we get one of those nice preliminary information sheets that back in the day they used to be faxed or part of your contract. Today I've seen them emailed with the same type of information. So they say, here's the preliminary notice information for this project. We have a case out of Force Framing versus China Trust that came out in 2010. The subcontractor had actually relied on a preliminary information sheet they'd been given about who the lender was. They sent their preliminary notice to this lender that they were informed was the project lender. Come to find out somewhere along the way in the project, they found out who the true lender it was, and it was not the bank that they had given the notice to. But by the time they went to serve their stop payment notice, they discovered the correct lender. They served their stop payment notice, and the lender claimed because they didn't get a preliminary notice, it wasn't served on them, that the stop payment notice was not valid. And the court was very sympathetic to subcontractors and suppliers on how difficult it could be to find out this information, and just said, we're not going to put a burden on claimants to do any investigation. If they're given information, they can rely on it unless they have some reason to believe it's not accurate. So if the information came back as undeliverable, or if the bank actually called you and said, we are not the lender on this project, well, then you have to go to the next step and do some kind of, like I said before, due diligence, do your investigation. But if you relied on the information and it was wrong and you had no reason to believe it was bad, you've got a good preliminary notice, even if it didn't get in the hands of the correct people, the correct owner, the correct lender, or the correct general contractor. And I just had this come up with a client who was told that the general contractor was above the subcontractor they were working for, and that's how they give their preliminary notice. We'll come to find out there were way more people in this chain, and it was another entity they didn't even knew existed, so they hadn't given their prelim, but they had in writing the preliminary information that they relied on. So I believe they're going to be good on that issue. These preliminary notices and all notices, we're going to go through this, but all your notices have to be given in writing, which is kind of makes sense, right? You can't just call someone up and say, oh, I'm, ABC supplier, and I'm giving you notice that I'm going to have some materials delivered to your job. So we got to do them in writing. In addition to the information that's required by a specific notice, so specific statute like a Mechanics Lien statute or a notice of completion statute. All notices must include the name and address of the owner or reputed owner. So the name and address of the direct contractor, the name and address of the construction lender, and as I said a minute ago, those are the people we have to serve with our preliminary notice. So we get their name and address on there. We need to include a description of the site sufficient for identification, and the statute says including street address if any. So if you're in the development business and you're in the grading and you're doing early site work, there often isn't a street address, or that's not something you would have information on. So if you have a street address, you include it. If you don't, we can use the old lot book title type information to identify the property. And then all of your notices have to include the name, address, and relationship of to the parties of the person giving the notice. So we generally read that part of the statute to mean just tell everybody who you are on the job and why you're there. I am a subcontractor. I am a supplier. I'm, you know, what is your role in the project is what we're defining as relationship to the parties. When some of this stuff might sound kind of odd if you're new to it, but the legislature is made up more of lawyers than they are of contractors. So they don't always define things as you would think in a business, construction business, things should be defined. So just define why you're on the job. Notices given by claimant. So a claimant is the supplier, the subcontractor, the general contractor, potentially. Anybody who can make a claim, one of those claims we talked about at the beginning, the Mechanics Lien, the stop payment notice, and the payment bond. So if you're a claimant, your notices must also include a general statement of the work provided. So what did you do? Plumbing supplies, or the electrical installation, electrical supplies. So just a general idea of what you did on the project. As the general contractor, it's a little bit harder to define overall construction as the general contractor. Just something. The name of the person to whom the work was provided. So this is who you directly contracted with, not the ultimate person who hired the work to be done, but the actual person right above you who contracted with you. And then a statement or estimate of the claimant's demand, if any, after deducting all just credits and offsets. So when we're at the preliminary notice stage, this estimate has to be specifically calculated to what we're going to end up supplying on the project. So we have to do some kind of calculation. It could be as simple as looking at our contract and seeing that we have a fixed price contract and we haven't yet received any change orders. And here's the amount we put in our estimate on our preliminary notice. We don't bump it up for potential change orders unless we already have them in-house. We don't automatically add 10%, round up, any of that. We do our preliminary notice for a specific estimate of what we believe the work is going to be on the project on the day we serve it. And the statute says specifically that the notice is not invalid as long as it substantially informs the person given the notice of the information required by the section. So what that means is you can put it in any format you want. Just make sure you include all the required information. You'll see on our forms, we have the box on the bottom for the notice to owner, and that's only required on private projects, but our form is a form that can be used on both public and private projects, so it's good for both. When you're serving the construction lender, you serve on the lender existing at the time of the preliminary notice. The direct contractor is supposed to tell you who that is, who they believe it is, or who they've been given information on who that is. If a construction loan is obtained after commencement of work of improvement and you've already given your preliminary notice, the owner must give the name and address of the new construction lender to everyone who served a preliminary notice. So if you're on the owner side and you've had a change in lender, you have the same obligation now to serve in the same method that the preliminary notice is served on all of the preliminary notice claimants information on this new lender, so that now everybody can go ahead and serve a new prelim. I don't suggest just a completely new prelim. I take the old one, I say updated or revised. Otherwise, the owner's getting this again and everybody's wondering if we're now double in our estimate and what's going on with that. So I'll update it with the new lender and reserve it. If a subcontractor has not paid all compensation due to their labor, so their employees generally, they must include the name and address of the labor and any funds which are due to like a trust fund, so union. If you haven't paid, this doesn't mean we're going to be paying this. This means our employees were supposed to be paid last week and they didn't get paid. Now we have to include on our preliminary notice all of these individuals who didn't get all their wages. This came specifically out of the downturn that we had in 2008 because employees were not getting their wages, and a lot of them ended up making claims, mechanics lien, stop notices on projects, and the generals and the owners said, well, we need to know who these people are who aren't getting their wages. It's a nice idea. I have not seen one of these served, although times have been pretty good, so maybe everybody's getting their wages today. But I think the problem is that most people, when they can't pay their employees, it's a pretty closely held secret. And you don't want the owner and the general contractor to know that, because they're gonna potentially cut you off and not give you any more money as a subcontractor. And so I don't see this getting served, but it's supposed to be done. There doesn't appear to be in the statute any penalty for failing to give this. Then the second thing is we also had the new labor code section 218.7 for all contracts after January 1st, 2018. This makes the contractor liable for wages, fringe benefits, and interest owed to employees of subcontractors at every tier. So this is generally now included in part of your contract with the general contractor to provide them with this type of information on your employees and what they're being paid. So there's an actual statutory obligation to share kind of with the general contractor the wages that you're paying to your employees if the general demands it. So I know some very sophisticated generals are obviously asking for this. Some are not, but I think it'll become more common. It is not a certified payroll, but it's something close to what is on the certified payroll form, same type of information, and the generals can demand that from the subcontractors. So when we serve the preliminary notice, again, I talked about we have to have a good estimate. We can't just guess at a number. And sometimes I see from suppliers in particular, just rounded up numbers. It'll say $10,000, it'll say $20,000. That doesn't appear to be a good estimate. So a good estimate, the court says, is some kind of figure that's derived through reasonable and logical attempt to determine a final number. So we have to, if we're renting equipment, my client that does the earth moving equipment, they will figure out, okay, 30 days for this piece of equipment at this many hours per day, here's the hourly rate, and they'll come up with their estimate that way. Like I said, if you have a fixed price contract, that's easy. You just throw in that number and plus any change orders you have already in-house. So we got to get a good estimate on the form. The court said if it badly misses the mark and it ends up being something totally different at the end, it's fine, because it just has to be valid on the day we serve the prelim. So if we get a lot of change orders, and I had a client who ended up having a contract that was about 5 times the amount of what he put on the preliminary notice, and we prevailed at trial on that case. Because on the day he served the estimate, he went through his calculations and he figured out what the reasonable estimate was. And so we had a good preliminary notice. As things change, so either scope of work changes or the amount of work changes, because we get a lot of change orders, we do not have to serve a new preliminary notice. The statute is very clear on that. We only have to serve a new preliminary notice if we have, and I don't know if I have a slide on this, let's see. Okay, so we only have to serve a new preliminary notice if we have given a final release, if we have a new project. So we finished phase 1 and we're going on to phase 2, and we only prelimed for phase 1. So we do a new preliminary notice, new project, or we have a new contract. So instead of issuing a change order we're going to expand and do new scope, and they go ahead and issue us a completely separate contract, we would do a new preliminary notice for that. So otherwise, one preliminary notice and we're good. Again, the McDaniel case from 2001, the court found it was one of these $10,000 estimates, and the notice, at the time the notice was given, this estimate was just simply a number. The supplier said they put on every single preliminary notice $10,000. If they don't do any calculation or determination of what the actual expense would be for the job, and the court basically said that is not a valid estimate. So we want to get that preliminary notice right, and we want to make sure we have all the proper information on the form. Then we have to serve the form, and what I'm going to talk about now is the notice. So how you give notice. This applies to the preliminary notice. This applies to serving your mechanics lien. This applies to serving a notice of non-responsibility if you're an owner with a landlord-tenant situation and you're going to post and serve your notice of non-responsibility, for serving your notice of completion, which on projects of more than 4 units on a private project have to be served on everybody who gave you a preliminary notice. So anytime, regardless of what place you are in the construction, you're going to serve a notice of some type, you have to follow the 8100. So we're gonna serve all documents by either personal delivery, which is fine. I don't recommend it because obviously you're not gonna drive around chasing down the owner, the lender, and the general contractor. It's much easier to put it in the mail. We always recommend registered or certified mail with the green cards coming back so that you know you have some proof of delivery. You can also now do overnight mail by an express carrier. So FedEx, UPS, one of the overnight services, or we can serve it in the same manner we're serving a summons and complaint, but that requires leaving the notice and then mailing the notice. So not the best method. We have to have two things. We both have to serve it the right way, but we also have to have a proof of notice declaration. So someone has to say on the form under penalty of perjury what notice they served, where they served it from, and on what day they served it, and who was served, what are the name and addresses. And that can refer to the first page of the form where you listed the name and address of the individuals that were going to be served. And so we have to have this declaration signed under penalty of perjury. And then we also have to have some kind of proof that it got delivered. So from the US Post Office, we can get the green card back. We can go on the US Post Office website and we can find a delivery receipt on there if we paid for the certified mail. That's the point. So we can look this up and show the delivery happened. So if you don't get those green cards back, and I know they're somewhat unreliable, go on the US Post Office and use the tracking numbers from your certified mail, print out the delivery from the post office so you have a record of the delivery. Or if you use an overnight mail carrier service, they're going to have the tracking record for you. So that is good, showing delivery of your documents. The statute also tells us where we should give the notice, where we should serve it. So for all of our notices, we should serve it at a residence, place of business, or any of the following address specified. So the statute specifically says to find out where the owner should be served, we should look to the direct contract. We can look to the building permit if we can go see or pull the building permit. We can look to the construction deed of trust if we were able to pull that, like from some title company. For the lender, we can look to the construction loan agreement or the construction deed of trust. For any contractor, so prime or subcontractors, we can look to the contract, the building permit, or the record of the contractor's license board. The statute says that's always a valid address. For the claimant, so if I'm the owner and I got to give notices back to the claimants, I should get the address from the preliminary notice, or I can look to a contract, a claim of lien if they recorded one, that stop payment notice, or again, I can look to the records of the contractor state license board. if they're a licensed contractor. And then lastly, for a surety, I can look to the bond itself, or I can go to the Department of Insurance website and get an address where I should serve a company. So now completion of notice. So this is not completion of the project, but this is completion of our service of the notice. When is it complete? So it's deemed complete when we put it in the mail. So if I'm serving that 20-day notice and today is the 20th day I've been on the job, it's actually valid the day I put it in the mail or give it to FedEx. We don't have to wait until it's been delivered. That's not our proof of date that it was delivered. So it goes from the day you put something in the mail, even if the post office drives around with it for a couple of weeks and it takes a while to get delivered. So that's our preliminary notice. Again, I'll take questions when we do our break at 10 o'clock on the preliminary notice and the mechanics lien. And the forms are in your packet. So we go through those specifically at the basic mechanics lien class, but yeah, the preliminary notice is so important that we also cover it in the advanced, just because it's where everything starts from, the preliminary notice. So in California, we do not have a notice of intent to lien. I see people giving that notice. It's not a bad idea to give it. It's just letting the owner know that, you know, we're going to lien your project if we're not paid, but it's not a valid California form, and it doesn't have any requirement to be served in California, unlike Nevada and I believe Arizona also. So if you're working in other states, each state has its own requirements on these types of forms. If you're at the stage where you did your preliminary notice, you finished your work, and boy, you haven't been paid, so maybe it's time to think about a mechanics lien. Mechanics lien is actually a security interest in the title to the property. So it's an involuntary lien, meaning you have a right to do it by operation of law. No one has to consent to your recording a mechanics lien. You're automatically given that right by under our California Constitution. But you must strictly comply with the statutory requirements to enforce the lien. So that's the preliminary notice and doing the lien in the correct manner. Again, it's only allowed on privately owned real property. So we can't have you lien and take public property, such as the streets. Those belong to everyone. So you can't record a mechanics lien against the public property, just private property. Mechanics lien for recording today has been a little bit more difficult for those of you who've had to do this during COVID. You know, we were talking before we started this about the whole new world we're in. That's why this is a webinar instead of in person. We used to do these seminars in person for the Baldy View chapter, but now we're bringing it to you by webinar because that's what we do. It's safe. Keeping everybody safe. So the county recorder has been closed. Last I checked, I think it's been about 3 weeks since I had someone call, but they were still closed. So the only way to get documents to the county recorder is to send them by mail. If you're going to send, and they only accept original documents at the county recorder. It is the only place still left in the court system that requires an original document. Everything else, preliminary notice, all the other documents we serve and use, a copy is as good as the original for the court. But the county recorder is particular, and they're so particular that one time I had them water test a document that my client had provided to me to record for them, and found that the proof of service document had a copy signature and not a wet ink signature. And when they water tested it, obviously looking to see if the ink ran, they sent the document back. So they can be very particular at the county recorder. We were sending our documents to be recorded through the mail. I believe San Bernardino and maybe Riverside have a drop box also, where you can leave it in a box outside the county recorder and it gets recorded faster. LA is incredibly slow right now. It was taking by mail 6 weeks or so to get documents recorded and back, and they did not backdate them to the date they were received, which would have been nice. But there are also electronic recording now in California. The title companies have been doing it for a while, so they have the ability to electronically record documents, but there are services, and we were able to get hooked up with one that can do this, where we send them the original document and they electronically record it. So that is a much faster process, happens within a couple of days. So if you're on a deadline, talk to me, or send me an email. And I have my email at the beginning there. It's ttate@builderslaw.com, but I can get you in touch with the people that do the recording on a much speedier basis than this mail service, which has not been fast. And the legislature and the California Supreme Court gave us a lot of extensions on deadlines because the courts were also closed for a long time. But so far, they have never given any extension on the deadline to record a mechanics lien. So we're still assuming the dates that have been set forth in the statute are the dates. No additional time based on the closing of everything for COVID. If you go and record a mechanics lien as a supplier or a subcontractor, or even the general contractor, and you do not file a lawsuit to perfect that lien. So we're going to get in towards the end. We've got all the deadlines set out for you. We've got, because I say a lot, it's 90 days, 30 days, so many days to do this and that. I've got lots of charts in the materials for you outlining those deadlines. But once we record our mechanics lien and we get the original recorded document back, we have 90 days then to file a suit. If we don't file a lawsuit with the court before that 90 days, then our lien is basically dead. And it still sits in the title of some developer's property, and their title company will usually require that they remove it or they bond around the lien. So they don't like to have even these dead liens in the title. So what they can do is the owner can petition the court to have the mechanics lien released once it's dead after the 90 days. They have to give at least 10 days notice to the claimant before filing the petition to remove the lien. So what I'll usually do for the owner and general contractor side, if we need to get a lien removed, we'll send a letter along with a completed release of mechanics lien form, demand that it be signed and notarized and the original returned to us. And if not, we're going to file this petition with the court. The good thing, if you're on the owner contractor side, is it provides for the recovery of attorney's fees for bringing this petition against the entity that failed to remove their dead lien. The bad thing is, for those of you suppliers and subcontractors, if you record a lien and you decide you're not going to pursue it, it is definitely expensive to retain a lawyer to file suit, but you need to get the lien off the property voluntarily. If you don't, not only do the people that owe you the money not have to pay you that money, but they'll get a judgment back against you for failing to remove the lien. And the statute used to provide for $2,500 in attorney's fees, and now it just says reasonable attorney's fees. So the judge can decide how much they should recover for having to remove the lien. The other way to get rid of a disputed lien is to bond around the lien. So that would be the general contractor, the owner posts a lien that is now 125% of the amount set forth on the mechanics lien itself. That document is then recorded, and the surety comes in and stands in the place of the real property. It doesn't get rid of the mechanics lien or wipe out anybody's rights. All it does is have a surety step in for the real property, so the real property can be sold or have a new loan taken out on it without the chain of title being affected by the mechanics lien, because now the surety has stepped into the place of the property. If you are working in a landlord-tenant situation, or either on the owner side, the tenant side, or the contractors, suppliers, you need to be aware of the notice of non-responsibility by owner. So it only applies in those scenarios where the actual owner of the property, the real property, has not contracted for the construction. then the owner can both post at the site saying, I'm not responsible for mechanics liens. Basically, there's a form, and then they won't be responsible. So the tenant, to the extent of their leasehold interest, is responsible for mechanics liens, but the underlying landlord is not going to be responsible as long as they posted before construction started and recorded this notice of non-responsibility. I find that they're not often done correctly, either not recorded or not posted timely. They wait till after construction starts. I had one, they were well into demolition by the time the owner got around to posting the notice of non-responsibility. And everybody who was on the job early knew the day that they did so, and so we were able to show that it wasn't a valid notice of non-responsibility. So you got to follow the steps correctly, again, so the property owner is not liable for the liens. But it's important for you, those of you that are contractors, to know that this is possible, so to let your employees know when they're showing up on the job, if they see something like this posted at the site, you know, take a picture, send it to the home office, let people know that this notice of non-responsibility has been posted. So that's it on mechanics liens. We brushed through that quickly. Like I said, I spend a lot of time. If you just recently did the basic mechanics lien class, we actually go through the forms step by step. But this advanced class, we kind of go through them. It's more about the unique details on those two forms. And we're going to get into the stop payment notice, and then, like I said, into bonds. We've still got a few minutes before our 10 o'clock break, so we'll get started on the stop payment notice. It's unique to California. So I've had clients call me who work in other states as well as California and say, can we do this in Illinois? Can we do this in Florida? I think someone asked me recently. Some states do provide, I think it was at one point 10 to 12 states have something similar to a stop payment notice, but the true stop payment notice is very unique to California construction law. So it is served on either the owner or a lender. It could be served, as I said in the beginning, on a public project or a private project, either. And it requires that entity to withhold construction funds from the direct contractor. So if we're going to serve it on the lender, then the funds will be withheld from the owner and the direct contractor. If we're serving it on the owner will hold on to the funds and keep them from the direct contractor. Unfortunately for the subcontractor suppliers, it doesn't mean they withhold it from them and they send you a check and then you're all done. It's not that quick of a remedy. It's just like the mechanics lien. You have to go to court. You have to prove up your right to the stop payment notice. But the good thing is, once you've proved up your right to recover the money, then the money's sitting there for you. So you don't get to the end of a lawsuit and have an empty judgment. You instead have this pool of money set aside by the lender, set aside by the owner to know that you will be paid. We used to just call this form a stop notice instead of a stop payment notice. And people would be confused by them in relation to stopping work on the project. And so I actually saw at least twice someone try to take the stop notice form and serve it on my client, telling them to stop work. And it was kind of awkward because it didn't quite fit what they wanted to do. But the form has always been to stop the payment or the money, not stop the work. But now they redefined it so people wouldn't be confused, and we call it a stop payment notice. If you are serving a construction lender on a private project, so a bank, you have to bond the stop payment notice. If you are serving the stop payment notice on the owner, you do not have to bond the stop payment notice. And this is not like a payment or performance bond. It's a relatively easy bond to get. It's usually, depending on your credit worthiness, 2 to 3% of the value of the stop payment notice. So it is easier. Don't be, if you need to serve one, it shouldn't be the thing that keeps you from getting, serving the stop payment notice. The bond may be required. You may serve a bond for a private owner, but again, not required. and no bond to serve a stop payment notice on a public works project. The benefit of a bonded stop payment notice is it has in the statute the right to recover attorney's fees. That is not included in the regular stop payment notice section. So I had a client who worked on private development projects, and in addition to his mechanics lien, he always served a bonded stop payment notice. The mechanics lien does not provide for the right to attorney's fees. As I said, the stop payment notice does. So this would be his way to, if he had to collect from the owner, was to get his recovery for his attorney's fees. So it put him sometimes in a better secured position than others. The owner or lender is only required to withhold construction funds that are still available. So if we're thinking about serving the stop payment notice and the construction's been going on for a while, and we know the project is done, we have to be concerned that there may not be any funds to stop. This is particularly true if the public entity had a scenario where they fired the general contractor and had a replacement contractor come in, because they are allowed to use the funds first to complete the job. So they could run out of money at the end of the job. If they've released retention, it's all done. So you know you want your stop payment notice to hit after you have finished your work, but before the owner or lender has let go of all the money, because if they've let go of all the money, it's too late. A stop payment notice does take priority of the bank's payments to itself, their own interest, loan fees, etc. This was important back in this, you can see by this case in 2014, it came out of the slowdown in 2008. And it takes about that long, 4 to 6 years for something to get through the appellate court. So we usually see the effect of things coming out of the appellate court on a delayed basis. But the bank had a project, as many did back then, that came to a complete halt. They got stop payment notices from some of the claimants that have been working on the job. They decided first that the bank needed to be made whole on their construction loan. So they took the remainder of the money on the construction loan, or a big chunk of it, and to pay themselves interest, loan fees, and other expenses, and then told the stop notice claimants there was just a small pool of money left. The court said, no, the contractors get paid first, bank, you get paid second. So the bank couldn't put itself ahead of the claimants. The stop payment notice must comply with the requirements of 8100. We talked about that in the beginning. That's how we serve people. You must include a general description of the work provided, an estimate of the total amount of the value of the work provided, and the amount claimed may include only the amount due the claimant through the date of the notice. So all of our mechanics lien rights, we are only allowed to claim for the actual labor and materials supplied to the project, and either the reasonable value or the contractual price, whichever is less. So basically, what you contracted for, if you had an arm's length contract, it was not done, some kind of insider deal, is the reasonable value generally of the materials and what you're owed for that. And that's what you're allowed to include in the stop payment notice. The stop payment notice, unlike the mechanics lien, there's actual case law that is not clear, but we believe you can also include your delay and disruption claim in your stop payment notice, which are specifically those kind of soft costs are not allowed to be included in your mechanics lien. The stop payment notice may be served by the same persons entitled to lien. The exceptions of the direct contractor would not serve a stop payment notice on the owner. They wouldn't send them a notice saying, oh, please don't pay me. So instead, they can only serve that on the lender, which means please don't pay the owner my money, hold it there at the lender. So you only could serve it when there's someone between you and the ultimate person you're serving the stop payment notice. So subcontractors, material suppliers could serve on the owner, a public entity, or a construction lender. And again, it has to be accompanied by a bond if it's a bank. And if you want to receive a return notice letting you know when the time is up to file suit on your stop payment notice, you provide them with a $10 check, and used to be $2, and now you ask the public entity to give you that notice. I have seen many school districts and many public entities that will provide that notice anyway, even without receiving the check. It's quite common, but they don't have to. The bad thing is you can't rely on this. Even if you gave them a $10 check and you asked them to let you know when the project was complete and the time to enforce the stop notice was up, there's no penalty if they don't tell you. So it's not like it extends indefinitely your rights on the stop payment notice. You still have to file suit within the required statutory time. So then once you file a lawsuit on the stop payment notice, just like you would file a lawsuit to perfect your mechanics lien, you have 10 days then to your attorney has to let the owner and the general contractor know that you've commenced an action. So we have to serve this notice of commencing an action. And that's kind of to let the bank or the public entity and the general contractor know that we don't have a dead stop notice situation where one was served but then never pursued with a lawsuit. So we have to, once the public owner accepts the project, this is just on your timing of actually serving the stop payment notice. It runs just like a mechanics lien, and I said we'll get into that at the end, but we have 90 days after actual completion or 30 days after notice of completion if we're a subcontractor to serve the stop payment notice or to record the mechanics lien. And then once we serve the mechanics lien, our time starts running right away to 90 days to perfect or file a lawsuit. That's not true with a stop payment notice. We don't have to file a lawsuit within 90 days of serving it. Instead, we get to wait until the whole project is done, and then our 90 days starts to run on filing our lawsuit. So we have a lot more time to pursue our stop payment notice than we do our mechanics lien. And this is the form. I think we should go ahead and take our break. We'll do it about 10 minutes. So about 7 after, because I have 9:57. I'll come back and I'll answer any questions that you post. So put them in your Q&A or the chat box, either is fine. Then when we get back, we'll walk through the stop payment notice forms and then move on to the payment bond remedies and your release forms. And that's what we'll do. Okay, everybody, it's just about time. Another minute or so to get your coffee before we start back into this. The Mechanics Lien. We did have one question. We had two questions. One was about the chat box. I can see it. If you can't see it, look under your More tab. The chat box should be there, but I don't have any control. If it's not, BIA is the host of the event. So it shows up fine for me. If you cannot access the chat box, you can send me an email at ttate@builderslaw.com and I can send you the Dropbox link with all of the documents. So that's another way to get everything if you don't get over to the chat box also. We had a second question about the timing of the service of the stop payment notice. I'm going to go through all the timing events at the end, but just to make it clear now, the stop payment notice has to be served within 90 days after actual completion or 30 days after a recording of a notice of completion. So that is your time for serving your stop payment notice. And then after that time, you have 90 more days to file the lawsuit. So you have either 30 plus 90 or 90 plus 90 to file your lawsuit on your stop payment notice. And we'll go through what is completion, because it's different on public works and private works. So it depends on what type of project that you're working on. Okay, so back on this stop payment notice form, and I'll get rid of me then so you can see the forms. So the stop payment notice, this is our form. There could be in all different formats. Just get one you're comfortable with working with. We have it in Word on our website, so just download it if you want and rearrange it until you have it the way it's easy for you to input the information. So the first thing we're going to do is we're going to put in the top the two. That's who we're serving the stop payment notice on. That's who we want to stop the money. So it could be the public owner, it could be the construction lender, it could be the private owner, and their address that we're going to serve this to. We're going to define the project. So we should know what that is. We did that on our preliminary notice. What's the name and address of the project? If it has a name for the project or some kind of legal description, something that defines what is the project that we're serving the stop payment notice on. Then with every form we serve, we must list the owner or reputed owner. So reputed owner means who we think is the owner, who we've been told is the owner, the direct contractor, and the construction lender, if any. So those three people have to be on all our forms, from the preliminary notice to the mechanics lien to the stop payment notice. So we're going to include that information. And take notice that by me, I'm the claimant. So either I'm a supplier, I'm a subcontractor, or maybe I'm the general contractor. I have a claim of stop payment notice. I give the address of the claimant, and the relationship to the claimant to the other parties is, as I said, define material supplier, subcontractor, what your relationship is on the job. The work furnished by the claimant is, so we're generally going to describe our work, plumbing, electrical, that kind of general description. And the labor and materials were furnished at the request of the following party. So this is who hired us, who contracted with us, who gave us a purchase order or a subcontract, who had us deliver the materials or provide the subcontracting work to the project. Then the stop payment notice has a section, unlike the mechanics lien where we just put the bottom line of what is owed. The stop payment notice has a section that I call show your work. So what is the total value of the materials and labor that you've actually furnished to the job? And then the value or the contracted to furnish. So this could be your contract price plus your change orders, what you've actually furnished. These could be different numbers. Maybe we got terminated or the job came to a halt before we were done. So, or they could be the exact same number. What we've done to date is everything we were supposed to do. And then what we've been paid and then the net, the difference between the value of the labor furnished and what we're owed, so the bottom line number. Then there's a direction to whoever's receiving the forms that they're required to withhold by law, the construction funds. You list the name of your company, sign it. Anybody who's got an authorized capacity can sign this. It could be your attorney, it could be the president of the company, it could be your controller, it could be anybody who's been authorized by the company to serve these documents. And then there's a verification form. So again, you're going to list the title of the person who's signing the verification section. And it says that I have read the stop notice and I know of my own knowledge that it's true. And I'm going to declare under penalty of perjury that this is true. I'm going to execute it wherever I signed it on that date and then sign again. Some forms have just a place for one signature down below. But we kept the verification form separate because the statute specifically calls out for a verification of the information on the form. Then the second page on our form is that proof of notice declaration, just like you have on a preliminary notice. This is the person serving it. Could be a completely different person from who signed the first page of the stop payment notice. This is the person who puts it in the mail or puts it in the place where your mail is picked up. So they're going to put their name, who they served, meaning we only have to serve this on the person that we're expecting to hold the money, and how we served, person delivery, certified mail, and then sign it again under penalty of perjury that we actually did the mailing. So we only have to send a copy of this. We don't have to send the original. So we fill it out, keep a copy for us, send the original, or vice versa, send the copy and keep the original in our files. And we serve it by the appropriate method. So the certified mail, return receipt, and asks them to hold money. At the very top would be the election if for a private works, if you want to find out that they actually posted a payment and performance bond. So that you can do that on a private works job. And then, again, I just mentioned this private works election only to let, if they have posted a payment bond, so it actually has to be not just obtained for the project, but it has to be recorded. Then they don't have to honor stop payment notices, and they have to let you know that if you signed this on a private works project. So always worth signing this if you're serving this on an owner or lender, so that you can find out if this payment bond has been recorded. It's very rare to have that done, but something you can ask for. Then again, your proof of notice declaration, fill it out just as I said a minute ago, with your name, who you're serving, how you're serving, check one of the boxes for the appropriate manner, sign it under penalty of perjury. So once you get the form filled out, it should be served at the following location. So again, the statute tells us, where do we serve the stop payment notice? The owner, other than the public entity, should be served at the owner's address on the direct contract. Again, the building permit or the construction deed of trust. The public entity, the office of the public entity or other address where the specific contract was let. So it could be Parks and Recreation, it could be State of California Department of Corrections. So we're going to look to the specific entity that let the contract, and that's where we're going to serve our stop payment notice. And then again, for the lender, we already talked about how to figure out where that should be served. If you're been paid or you want to be paid, so you have to release the specific stop payment notice that you've now served, your money's been held, but the owner comes to you or the general contractor and says, okay, we're ready to pay you, we need to release the stop payment notice. You cannot release or give a release of stop payment notice for a check, because the check could be canceled or stopped and you would have given up your rights to the stop payment notice. It's already gone, the money is released. So we generally wait to give the release of stop notice until we either have a cashier's check, some kind of certified funds, we're going to get the money directly from the public entity so we know it's good. Or somehow we do it through a lawyer's office so we know that, or escrow is a good place to exchange these documents. We know we're going to end up with the money at the end of our release. But the statute now specifically provides for a release of stop payment notice. We've always used a specific form called a release of stop payment notice, but the public entities, when we did the rewrite of the Mechanics Lien laws in 2012, were saying that they were concerned with their liability for letting go of stop payment notice funds based on use of a stop payment notice form or release form. And so the statute now specifically includes, not for a Mechanics Lien or a payment bond, but for just the stop payment notice, a release of stop payment notice. And if you release that specific stop payment notice, it does not release your right to serve another stop payment notice. You're solely giving up your right to those funds that were stopped by that particular stop payment notice. The only forms that can release your rights to a stop payment notice, a Mechanics Lien, or a payment bond are the statutory forms, the conditional and unconditional release for progress or final payment. So this specific form releases a specific stop payment notice. So if I served one early, but because I was done with my work, you know, everybody comes in the job potentially at different points. So a lot of the subcontractors come at the beginning and then they're off the job and they're not around for a long time. And then other people, the landscaping, the carpeting, flooring, they come at the end of the job. So it's a little harder for them to serve a stop payment notice, let it go, and then potentially file another stop payment notice, because the time would likely expire by the time they finish their work. That clock is ticking and running on serving the stop payment notice. So this is what the stop payment, release of stop payment notice form looks like, the one that we have on our website. I've seen it commonly used and accepted by public entities. I even had a school district, I asked them for their form so we could fill it out, and it ended up being our form because we put information on the bottom. So they're widely downloaded, which is great. That's why they're there. They're free. There's no charge. The point is to get the proper forms out to everybody to use in the industry. So you fill it out just the same way you did the stop notice, identifying who you're sending it to. This is the person you sent the stop notice to. And you are hereby notified that, again, it's just the reverse, the claimant, and that particular stop notice that was served, and it's being released. Again, it's a verification form. It is not a notarized form. The release of Mechanics Lien does require a notary. A public entity could certainly ask you for a notarized form. The statute doesn't provide one way or another, but it does say it has to be verified under penalty of perjury. So that's your stop payment notice. If you have a disputed stop payment notice on a public works project, there are several, well, actually on any project, there are several ways to get rid of the disputed stop payment notice. You can bond around it, just like you can bond around a Mechanics Lien, where a surety comes in and releases the stop notice funds, allows them to be released from whoever's holding them, and then the bonding company or the surety stands in the place of those funds. So stop notice doesn't go away. It's just, instead of a pool of money set aside for your benefit, now the surety steps in as the person responsible for your claim. On a public works job, the release of stop notice bond must be a different surety than we had posted on the payment bond. And the reason is that we have seen at certain times surety companies go bankrupt or out of business. It hasn't happened that I've seen in a long time, but it has happened before in the past. So the idea was, we can't just use the same surety because we're not now protecting those stop notice funds separately from our payment bond rights. So we have a separate surety coming into play to stand behind the stop notice funds. if the direct contractor wants the funds released on a public works job and does not want to post a bond, there's an affidavit summary procedure. And it's important, if you are a subcontractor or supplier using the stop payment notice as a method to be paid, that you're familiar with this affidavit procedure, because you will receive this in the mail and you only have 20 days to respond. So it's important that you be aware that this exists and that you know how to respond. So the direct contractor basically fills out an affidavit. It could be on their letterhead, any kind of form saying it's an affidavit. They must indicate that the claimant is a person not authorized by 9100, so that's our statute giving rise to the stop payment notice, is not a proper claimant for one reason or another. Maybe they didn't serve a preliminary notice. Maybe they're claiming funds to which they're not entitled. So whatever their basis is for claiming that the stop payment notice is not valid or is excessive, and they ask the public entity to release the funds through this affidavit. The direct contractor shall serve this affidavit on the public entity in the same method as the 8100. So certified mail, return receipt, personal delivery. And it has to include the information, the allegation of the grounds for release, a demand for release of all of the money or a portion of it, and a statement of the address of the contractor for service. Then the public entity takes the affidavit and sends it to the claimant. It has to be served again by the same method, the 8100. Certified mail, return receipt. They send a copy of the direct contractor's affidavit, a notice stating that the public entity will release the funds or have the right to release the funds if they don't receive a counter affidavit before the time stated in the notice. And the time stated in the notice shall be not less than 10 days nor more than 20 days. They generally make it 20 days. So you'll get this notice in the mail from the public entity. You have to then serve a counter affidavit. The counter affidavit by the claimant has to be served by 8100. So we need a proof of notice declaration or proof of service. And then we also need to serve it by certified mail, return receipt on the public entity and the direct contractor. We give all the details about why our claim for a stop notice is valid, that we served a preliminary notice. I usually attach a copy of it, or if that is the basis for the affidavit, outlining our claim to why we're entitled to be paid, send it off to the public entity. If no counter affidavit is timely served, the public entity must release the funds without further notice to the claimant. So in other words, don't ignore this affidavit procedure if you get an affidavit in the mail. If the affidavit or counter affidavit is received, the public entity is not liable for the validity or for weighing the issue. You know, they don't become the decider of fact. Every public entity I've ever worked with that has received a counter affidavit has continued to hold the funds and not release them. They don't, again, like I said, weigh who's right and who's wrong. Generally, they'll just make you go to court and prove up your stop notice claim. So if you served a stop notice, make sure you serve the counter affidavit. If you're a general contractor and you have a subcontractor you really believe is not entitled to the stop payment notice, this is a relatively easy way. I mean, you don't have to pay the surety any kind of 2% or 3% fee for that stop notice release bond. And this is a way you might be able to get your funds released without posting the stop notice release bond. The stop payment notice, again, you must file litigation to perfect it. Just like the mechanics lien, these things aren't self-perfecting. You cannot file suit to enforce a stop payment notice until 10 days after serving the stop payment notice. And then the deadline to file suit is 90 days after the time within which to serve a stop payment notice. So again, you have 30 days after a notice of completion to serve the stop notice, or you have 90 days after actual completion to serve your stop payment notice, and then you get another 90 days to file the lawsuit. So it's either 30 plus 90 from a notice of completion for subcontractors, and suppliers, or 90 plus 90 if we never have a notice of completion recorded. If you don't timely enforce the stop payment notice, and again, I told you we had to serve this notice of commencement of action, so everybody knows the lawsuit has been filed. It's supposed to be served within 5 days of filing the lawsuit, so that's something your attorney should do. Then the funds can be released because you failed to pursue it by perfecting it and filing the lawsuit timely. So we finished the stop payment notice. I don't see any new questions, but again, I'll take them when we take our break. We're going to move on to bonds. So bonds are something that you need to know about on private works as well as public works. Obviously more common on the public works because they're required on public works projects, but there are often either hidden bonds or bonds just available on even private projects. So required on all the public ones, but sometimes required or posted on a private project. Sorry, I'm confusing that. It's a form of credit is what suretyship is. The surety bond is based on the underlying contract, which must be in writing according to the statutes. So the bond surety comes in and posts the bond on specific contracts. It's like insurance because if you're familiar with bonds, any kind of bonds, these mechanics lien release bonds, the payment and performance bonds, they're written by surety companies, which are like insurance companies, or they are insurance companies, just a different arm usually. They're a three-party, the surety, the principal, and the obligee on a bond. Losses are not expected on a surety bond, which is why the premiums tend to be based on the personal history or the credit of the person requesting the bond. They're not cancelable, unlike your insurance premium, which is cancelable. And insurance, pretty much losses are anticipated, and it's the potential losses that they base the premium on. The special legal rights and obligations, because you're coming in after a bond, and you have to follow both the statutes, and on a private work bond, you have to follow the terms of the bond itself. So this is what a surety obligation looks like. We have the principal, that's the person who's required to post the bond, usually the general contractor, but sometimes subcontractors have to bond projects too. And then the surety is the person taking the risk on the bond, basically standing behind the principal. And then the obligee, this is the person who requires the bond or benefits from the bond. On a performance bond, the obligee is usually the owner or the person who is going to get the benefit of the services from the contractor will be the obligee. And so that is the person who gets the benefit on a payment bond. So that is the bond that secures payment to everybody who supplies labor and materials to the project. Basically, the obligee is anybody who has potentially a claim and who follows and jumps through the hoops of the statute. That's for whose benefit the bond is issued. So the surety's obligations, they're limited to the penal sum of the bond. So the bond will have on its face the value of the bond. Generally, it's for the amount of the project or even above the amount of the project, so there's plenty of money. However, Caltrans allows a 50% payment and performance bond. Good news, if you're a general contractor working for Caltrans, you save some money on the bond. Bad news, if you're a subcontractor and supplier, only half the value of the contract is there to protect you. I had claims on 7 or 8 projects for a subcontractor on Caltrans projects. The same general contractors working throughout the state for Caltrans. And they basically got about 90% of the jobs done, collecting all the money from Caltrans, paying none of the subcontractor suppliers, and then just disappeared. So only 50% of the bonds. In that case, for both a stop payment notice and a payment bond claim, then all the claimants are paid on a pro rata basis. So not one person, whoever is first, gets all the stop notice funds or all the surety funds. You figure out everybody's value of their claim and the percentage of the total amount in the funds held, and everybody gets a pro rata divvying up of the funds that are available. The only time you can go beyond the penal sum of the bond is if the surety fails to timely pay, basically some kind of bad faith, or the surety steps in and assumes the obligation of the principal. So sometimes the surety takes over a project and they're completing the project. So it's more than they have a contractual obligation to that's outside that bond. The surety could be not liable if they find that the contract was not binding or illegal. Their judgment gets entered in favor of the principal. So you pursue recovery on your contract and the court says, no, the general contractor doesn't owe you subcontractor any money. The bonding company then is also free on the bond. So it arises out of that contract, and there has to be an obligation by the principal to pay you that the surety is standing behind. If a subcontractor is unlicensed, then they are going to lose their right on the payment bond, also on their mechanics lien, their stop notice. We don't allow unlicensed contractors to pursue recovery of claims in California. Or there's some failure to perform a condition precedent or a fraud involved, then the surety could potentially not be liable. Common types of construction bonds. Every contractor has to have a license bond posted with the Conductor's License Board. It's a small amount of money though. Sometimes worth pursuing, but sometimes there's so many claims and it's such a small amount of money it's not worth. If you're bidding directly to a public entity, you have to post a bid bond, and that just says, I'll stand behind my bid and enter into a contract with you. And if I fail to do so and pull out, the bonding company, the surety, will pay the public entity. We have performance bonds. Again, performance. I'm going to finish the job. I will perform. Payment bonds. Payment bonds say, I will pay everybody who supplies labor and materials to the project. I'm going to make sure everyone is paid. Always required on public projects in excess of $25,000. Also some private projects. So many big privately owned developers, you know, Disney, Irvine Company, others I've seen require a payment bond from the general contractor, and that's just to ensure that they don't have claims on their property. We have a mechanics lien release bond. We talked about one way to get rid of the mechanics liens on the property. We have stop notice release bonds. So lots of different types of bonds. The license bond, I talked about, small amount. If you are a claimant that is not a homeowner, you don't get to collect the full amount of the bond. You only get to collect, the surety only has to pay out $7,500 to subcontractors and suppliers. Only homeowners can claim the full $15,000 of that bond. Bid bonds, we just went through. Performance bonds, release bonds, stop notice release bonds, again, talked about those in detail. So the payment bonds, sometimes have those on private works, always on public works, always on federal projects. That's called a Miller Act bond on a federal project. But again, of any decent size, I believe the federal projects is a higher limit. It's 50,000 or 100,000 on the limit on when a bond was posted. And then we have public-private partnerships now. In the beginning, when California started to get into the public-private partnerships, the P3s, those were unbonded, and it was leaving everybody very concerned. If it's public property, I don't have mechanics liens. Who do I serve a stop notice on? Because I'm not sure who's even funding this public-private project. It has both private aspects and public aspects. So starting in 2014, the legislature required that payment and performance bonds be posted on the public-private partnerships. So now you got bonds on those. So if you want to satisfy or make a claim on a private payment bond, You have to satisfy all the conditions precedent, and those are what's stated on the bond. So if you get a copy of the private work payment bond, it often says things like, you must provide notice within 6 months of finishing your work to the contractor and to the surety that you have a claim. So they'll have their own requirements on the face of that bond. That bond is basically just a contract. It's not required by law on a private job. The term of the bond gives its rights and obligations, incorporates often the terms of the written contract, and all requirements of the written contract have to be met to make a claim. So protecting your rights on a public works bond, you must serve the preliminary notice, which is generally going to be required on the private too, but it doesn't specifically say that in the statutes or the case law. We have to give, if we didn't give a preliminary notice, then we do a notice to surety, and that is served either 15 days after notice of completion or 75 days after actual completion. You can serve the notice to surety if you need to serve it because you didn't do a preliminary notice. But if you just do your preliminary notice, you don't have to worry about a notice to surety. You must satisfy all the condition precedents again, but these are statutory condition precedents. They're all set forth in the statute, and the statute is read into the bond. The bonding company can't have its own private conditions in the bond itself. Only those in the statute can be read into the bond. And you must file suit on a bond no later than 6 months from 30 days after notice of completion or 90 days after actual completion if no notice of completion is recorded. So we either get 30 days plus 6 months or 90 days plus 6 months. So we have more time, you can see, to file and pursue our payment bond rights than we had on either our mechanics lien or our stop payment notice. Extra time. So some people let their stop payment notice rights go and they'll wait for just going after the payment bond if they know they have a good surety and a good payment bond. Most people consider it like belts and suspenders. They'll also go after their payment bond and their stop payment notice on a public works project. So it's up to the company on which they want to pursue, but you can pursue potentially all three. If you had a private job that also had a bond posted and a mechanics lien right, you could do your mechanics lien, your stop payment notice, and your payment bond claim. They are not mutually exclusive. So here's who's entitled to claim on a California Public Works payment bond. We allow subcontractors of every tier. So the prime contractor is not going to be making a claim. They're the ones usually posting, as I said, the obligee, the bond, but subs of every tier. So you could be a 5th tier subcontractor, and the difference between subcontractors and material suppliers is you actually have to do some work at the project to be considered a subcontractor. And then material suppliers to any contractor, any subcontractor is allowed to claim. What we don't allow is subcontractors to material suppliers or material suppliers to material suppliers. So everybody below the dotted line is not allowed to claim on a project. And this is true for either the Public Works payment bond, it's true for the mechanics lien, and it's true for the stop payment notice. So we never allow material suppliers to claim, and that's because it's too hard to trace the specific materials into the project. But it could be that you're doing specialty manufactured materials. So we could have an exception there, but for the most part, we got to be some type of subcontractor doing work at the project in any tier, and then all of the suppliers to those subcontractors to make a claim. California payment bond claims require the preliminary notice. I told you that at the beginning. If the preliminary notice was required and you didn't do it, I just mentioned this a minute ago, there's like a backdoor into making your payment bond claim. And this is because back when I first started practicing, you didn't even have to serve a preliminary notice to have a payment bond claim. you were actually allowed to be completely in secret, never having served a preliminary notice, and then make a payment bond claim, either on a public or private payment bond, without having served your preliminary notice. So that changed about, time flies, but 10, 12 years ago. And now requiring the preliminary notice to make a claim. And if they put in some help, because a lot of subcontractors complain, well, we're not used to doing them on public works projects. So if you didn't serve the preliminary notice, you can have this backdoor in through the 1575-day notice. That was a compromise between the AGC, which is the trade association that represents general contractors, and the ASA, which represents subcontractors. But then a few years after, they went ahead and changed it where they still allow you to have the 1575-day notice, but if the general contractor didn't know you existed and they already paid the first tier sub all of the money because you were hidden, not having served your preliminary notice, and instead after the job is all done and after they paid out all the funds, they receive your notice to surety, then they have a defense now. So the general contractor doesn't have to pay twice if you didn't serve a preliminary notice, and they can avoid paying because they already paid. So again, just serve your preliminary notice, and then you don't have to worry about the 1575-day notice, and you don't have to worry about the general contractor having a defense. And yes, you can make them pay twice, even though they've already paid out all of the money. And that's particular to California law and completely enforceable. So if you have to do a notice to surety, this is our form, but it could be on your letterhead. You could do it any way you want. It's just to say, I use this form for two things, actually. One, I use it for my 1575-day notice. For my clients come to me and they say, oh, forgot to serve the prelim, or I had a defect in my preliminary notice, so I need to serve the notice to surety. I will fill out a form like this to serve my 1575-day notice. Or I also use this form just to let the surety know we have a claim. There is no form to say, hey, surety, I haven't been paid. I'm looking to you to pay me. And if I don't get paid, I'm going to file suit. You could do that by a letter. But I prefer to just fill out this form, send it off to the surety by certified mail, return receipt requested. Let them know that we are a claimant and we finished our work and we haven't been paid, and so we have a claim on the project. The surety, every single one of them will send you back their own form. We can't fill that out in advance because it's different for every single different surety. Their form will require some kind of affidavit, maybe a notary. Will require they'll ask for all your backup documents, your contract, your billings, change orders, everything you have on the job. So you serve something like this to start the process, and then when you get the surety's own form, you go ahead and fill that out, provide them with all the documents. We don't keep secrets from the surety. The idea is if we can informally get paid or help the surety to pay you, then you want to do that without having to file litigation, because obviously litigation is expensive. The good news, though, is that if you have to make a claim on a payment bond, is they provide for the right for attorney's fees. So like a bonded stop notice, the payment bond has the right to attorney's fees recovery for whoever prevails, whether that be the principal and the surety or the claimant. So we fill out this form, putting in the name of the surety. We need to know who that is. So we somehow need to get a hold of that payment bond so we can make our claim. If it's a private works bond, it can be pretty hard to track down, and people don't like to share. On public projects, pretty easy. Get a hold of the public entity that let the contract, and under California, what we call the Sunshine Laws or Freedom of Information Act, they must provide you with a copy of the bond. Caltrans is nice. They post it right there on their website. They tell you who the bonding company is, so you can give the proper notice. all the other public entities, some are getting much better about having really good websites for their projects. But if they don't have that for you, then go ahead and do a written request. They'll accept email as the written request for a copy of the bond. So you can give this notice to surety. And then we also have to list the bond principal and then from the claimant. So that's you, subcontractor, or supplier. Please take notice that the claimant has provided, again, this is the description of the project, generally known, the type of work the claimant provided, the name of the person to whom the work was provided. This is who we have a direct contract with, who hired us, and the relationship to the parties, again, as with all statutory forms now. This form is 2 pages. We do a description of the site. So this is where we're going to put in the address or the legal address of the construction project. The claimant is owed. So this is our bottom line demand, subtracting all credits, all monies that we got paid. This is what we need to be paid. So this needs to include, as with our stop payment notice, as with our Mechanics Lien form. By the time we get to serving these documents, they need to include everything. Our retention, change orders, even if they're disputed, everything we believe we're entitled to if we have a good faith basis for making that claim, all progress payments that haven't been made. So we don't do these over and over again after we didn't get a progress payment for a certain sum. We wait till we're done with our work, then we fill this out and we put in everything we believe we're entitled to be paid on the project. And then every form has to have the owner, reputed owner, the direct contractor, and the lender. So true for this form too. And we have a proof of notice declaration. So this is what we're going to do for any form we have to serve. When I've told you there's a proof of notice declaration required, that's the person dropping this in the mail or putting it where your mail is picked up. They're going to sign under penalty of perjury that they serve both the surety and the bond principal, and that they served it by the right, correct method. So one of these methods. Okay, so we have particular bonds for federal projects. They're called a Miller Act payment bond, and they're a little bit different than California projects and California bonds. So if you're doing any work for the federal government, such as on the military bases or some of the airports, those are federal property. Federal bonds are going to be posted. The federal courthouse, so any of those kind of jobs, just if your owner is the federal government, I think I'm still connected. Yeah, I got a little notice saying connected to audio. So hopefully I didn't lose everybody there, but so the persons in direct contractual privity with the prime contractor are protected by the Miller Act bond. Those that have a direct contractual relationship with a first-tier subcontractor. So that's the first thing that's different with a federal project, is that they cut off the tiers of who can claim on the bond much shorter than the California bond does. So it looks like this. So I think I got, okay, there it is. So second-tier sub, first-tier sub, material suppliers, and direct material suppliers. Everybody below that doesn't get to claim on the Miller Act bond. So it's a real short list of people that can make claims. Generally, if you're down the list, I would still make a claim, but potentially you're not going to be included in those persons covered on the Miller Act bond. The requirements. Again, I just talked about third-tier subcontractors not protected. Suppliers to second-tier subcontractors not protected. Anyone doing business with a supplier, same with California law, not protected. So the notice requirements on a Miller Act, there is no preliminary notice required on federal jobs. You also don't have to be licensed to work on federal jobs in California. They're owned by the federal government. They set their own rules. So no preliminary notice required. And you don't have to give any notice to the surety if you're a first-tier subcontractor or first-tier. And by that, I mean you're working with the direct contractor, the contractor who posted the bond, who's working for the federal government no notice required for those. So if you're a second tier subcontractor or supplier, you need to send a notice to the prime contractor and the prime contractor surety on the bond. So that is who has a contract with the subcontractor above you. The time deadline for doing that is 90 days from the last day the claimant performed labor or supplied materials on the job. So unlike California law, where everything runs from completion of the entire project, not completion of your own work, on federal jobs, the claims run from actual completion of your own work. So 90 days after the claimant performed labor or materials, must serve this notice if you're not a first tier. The statutes are much more loose in federal court too. The federal government said, oh, well, this 90 days is flexible. If you're a supplier delivering a series of materials, we're gonna let you wait until you finish the delivery in the series, and then your 90 days will start to run. And this came about when a rental company was trying to recover on earlier delivered items. The Miller Act bond, California preliminary notice not required, again, federal job. The notice that you do give must show the amount claimed with substantial accuracy, must name the party to whom the claimant furnished the labor and materials, and the notice must be sent by certified or registered mail. You have to file suit on your Miller Act bond, different timing than California. We already went through the California times, within 1 year after the claimant's last labor or materials supplied or labor performed. So it's a different statute of limitations on that claim also. And then again, like I said, the federal court has looser jurisdiction. In California, our statutes are specific. If you don't file by the deadline, you don't have a right to go to court. Your claim can be removed. So, but in federal court, they said, well, it's not jurisdictional. If you've been working with the bonding company and sending them claims, and we could extend the deadline on the 1 year. So I don't recommend going past your deadline, but it is looser in the federal claims, in federal court, than in California claims. And federal projects for Indian land, there's no, I already said this, no contractor's license required for federal projects, Indian projects on the Indian tribal lands. Also, the California Mechanics Lien laws, stop payment notice and payment bonds do not apply. They have sovereign immunity on the tribal lands. They don't have to honor any of those rights. I have served a stop payment notice on what they call their councils for Indian land projects, and I've had them honor them. So they consider like they will come in and negotiate and try to make sure that the claimants are paid. So they can be helpful to go ahead and serve your stop payment notice if you want to get somebody's attention and potentially try to get paid, but don't bother doing a mechanics lien. It won't be recorded. Or there's going to be likely to be no payment bond unless the tribe required that for their project. So it's a good time, I think. It's a little early, but it's a good time to take a break because we're at releases. And so we're going to move into the other forms. Okay, so the time, someone asked about the timing on the mechanics lien. We're going to get to timing, but specifically, but just so that you know, a mechanics lien must be recorded within 30 days after the notice of completion is given, or if no notice of completion is recorded and served, then 90 days after actual completion. Once the mechanics lien is recorded, then you only have 90 days to perfect it by filing a lawsuit. So that's your timing on a mechanics lien. And the charts Probably haven't had time to download the materials in the Dropbox, but there's a specific chart that has all these time deadlines, so you don't have to race to write them down. As I said, the PowerPoint is there also, so you can look everything up. So let's take a 10-minute break again till 5 after 11. We're going to go through the release forms, prompt payment penalties, and some of the miscellaneous items about the Mechanics Lien claims when we come back. Okay, it's almost time. Hopefully everybody got their bathroom break and their caffeine, and we're ready to finish this up. We have a question that hasn't been answered in the Q&A, and that is, what is a bank guarantee versus a payment bond on public works projects? So I would assume that would be something like a letter of credit that would stand behind the contractor to guarantee either completion of the work or payment of the subs and suppliers. In 28 years, I have never seen a public entity accept a bank guarantee instead of a payment bond. Not that it couldn't happen. It would be up to the public entity, and certainly might be more acceptable on a P3, so the public-private partnership, than on a true public works project. Again, I haven't seen it, but it could happen. That would be the bank standing behind somehow the contractor. So that's the only question. If you have questions, throw them in the Q&A. We'll do this again towards the end when we're done to make sure you get all your questions answered. But for now, it looks like it's time, and I'll get back to the presentation. Okay, so our release forms, these are very important that, that you understand if you're the person doing this, or the people in your office that are doing the releases understand. I generally recommend that project managers, people on the project, not be the ones doing it, but more of accounting function. So the accounting office would provide these, so there's no pressure to give releases that are not appropriate being asked for and given. Basically, the statute in California provides that you are not allowed to release your mechanics lien, stop notice, or payment bond rights through your contract in advance of performing work. So those kind of contractual provisions in California are considered void and unenforceable. The only way to give up your right to a mechanics lien, your right to a stop payment notice, and your right to that payment bond claim is through the statutory release forms. So we've had these release forms now around for more than 20 years. They were changed in July 1st, 2012, like everything was changed. The legislature indicated that they had recast the forms for clarity. And again, when we have a bunch of lawyers in the California legislature making changes and recasting things for clarity, it doesn't mean clarity to a contractor or people that use these forms. It means to the lawyers. They thought this was clear. So they rewrote the 4 release forms. You've got the statute numbers there, 81, 32, 34, 36, and 38. They attempted to solve some of the problems that we were seeing for years with the forms, where people were modifying them all the time. It was not uncommon. I saw a modified form with some kind of asterisks and some kind of putting additional language in. The thing is that the legislature, for most of the forms we've talked about this morning, the mechanics lien, stop payment notice, the surety claim, they tell you what has to be in the form, but they don't tell you how to put the specific language. They don't care. They just want you to include the right information. Well, that is not true on the release forms. If you pull up these statutes, and you can Google it, California Civil Code 8132, you will see that it actually lists the specific language that must be included in the form. So they actually spelled out in the statute what they want the forms to say. So we can't deviate from that. If we do deviate from the standard form, then we potentially have a voided form. A voided form is going to hurt the owner or the general contractor. They're the ones who rely on these forms. So there's no harm in voiding potentially a form if you're a supplier or subcontractor. But owners and generals need to be careful to make sure that they're getting the true statutory form. These forms are only intended to release your stop notice, payment bond, and mechanics lien rights, not your contractual rights. So you always have a breach of contract, or potentially someone hired you, they owe you the money for the work. That breach of contract claim is completely separate than the rights we've been talking about this morning, which are your statutory rights. So that's what these forms are intended to release. But I do see some out of state in particular, or big general contractors who have like a dual form. It'll have the California statutory language, but then it also goes broader and does indicate a release of your contractual rights also. So that probably wouldn't violate the California statutes as long as they did include all the proper language from the statute. But sometimes I even see forms, I saw one not too long ago from a New York contractor, and it was clearly some kind of form they use in New York to release rights, and it wasn't even California's forms for a California project. So that is going to be invalid. It's going to be void and unenforceable. It's not the proper form for a California release. So the waiver and releases, again, I said they moved that bold language that used to be on the bottom of the forms to the top of the form now. I'm not sure why, but I guess they thought all of us weren't reading to the bottom of the forms. So they wanted it right there at the top in the front, at the very top of the form, the bold notice language. They added language to the conditional waiver and release on progress payments that allows you to show what prior progress payments you haven't been paid. Because remember how I said everybody was modifying these forms? This is where I always saw these asterisks, but things like does not include invoice from last month and different things spelled out being accepted. And all the forms have added a line for identification of the waivance customer. The release forms for final payment. So they got the two for progress payment, the conditional and unconditional. Then we've got two for final payment. They did not make the same changes. So they didn't clarify or help subcontractors and suppliers when it comes to the final payment. You are not allowed to exclude prior progress payments that you have not received. Doesn't include a section for this. The only space to be filled in that you haven't been paid are for extras. You can exclude extras from the release. So some people who don't do public works seem strange, but you would still have a dispute about change orders when you're trying to get paid your retention. And that is exactly what this form is for. It is not horribly uncommon on public works projects to be fighting about change orders for a year or two later and already have your retention released and still have open change orders. So they just take a long time to get those released. We have the Halbert's lumber case. This was on the old forms, but it still is applicable today from 1992. It says furnished on the forms means actually furnished to the project, not when it is billed. So I have people ask me a lot about, but we didn't bill this until some later time, or we didn't bill for that, so it's not included on the release forms. It's not what the forms say. The forms say we've included all labor and material furnished through the through date. So in the Halbert's case, there was a lumber company who was furnishing beams to the construction site. The beams were delivered by their downstream supplier to the project. By the time the paperwork got back to the home office, billing, it was the end of the month. So let's say on the 29th, the beams are dropped at the project. 30th, the billing goes out. They do not include those particular materials, and we're talking expensive materials for these glulam beams. And they gave a waiver through the date, let's say the 30th, and the court said that through date means what it says it means. So it says all equipment, labor, and materials delivered to the job site, even if you haven't built it, even if you haven't installed it, I'm releasing through this date. And in the Halbert's lumber case, they lost their right to claim because they didn't include in their release those materials that had been delivered to the job site. So let's take a look at the forms, and I think I only included the conditional, the progress, and then the final. So the conditional waiver and release upon progress, we're going to do the name of the claimant, that's our subs or suppliers. The name of the customer, that's who hired them, not the ultimate customer who used the goods. The job location, description of the job, who the owner is, and then we've got our through date. This is the important date. I know everyone says that this through date has to match your billing. So if your invoice says the 25th, the through date, they want it to match your billing date so that they can match these things up. That's not really what the legislature intended. They didn't intend these release forms to be billing or accounting type forms. They really intended them to be legal forms that are releasing your right to a mechanics lien, a stop notice, and a payment bond. So be very careful of that through date. But they did give us some help when we rewrote the statutes. So again, it says right on it, this document releases your stop notice, your payment bond, and your mechanics lien for the through date. It doesn't have anything to do with your contractual rights. And here's the exceptions, and it specifically gives you exceptions that are noted below. But first it says, this document is effective. It's the conditional. It's only effective when you actually receive payment. So if you're waiting on payment or you haven't gotten a cashier's check, you're going to give your conditional until after that check clears, and then we give the unconditional. The only condition between a conditional and an unconditional is payment. So once we get payment, we give the unconditional. When we're waiting for payment, we give the conditional. So then we say who we want the maker of the check. I don't really think this is critical to the form if someone else gives us a check and it actually clears. The amount of the check and who it should be payable to. Maybe we want it a joint check, or maybe we want it payable directly to our supplier. So we can identify that on the form. I've got exceptions on this form now. We didn't used to have these. People used to type in their own exceptions. So it doesn't include any retentions that we haven't billed. So here is a place where what I billed is relevant versus what I haven't billed. So retentions automatically excluded. Extras for which the claimant has not received payment. So all approved change orders that I've billed for, I have to include, but if I'm still got pending change orders, I don't have to worry about them. They're automatically accepted on this form. Also accepted from my form are prior progress payments for which I haven't received payment. So we don't leave this blank and we don't put in 0 if we have prior progress payments. So if I didn't get, I'm billing now for July, let's say, I didn't get my May or my June payment, I need to list my May and my June payments here. I prefer that you don't accumulate, so you don't put in one amount for all the prior. If you billed separately in those 2 months, then you list the May billing and then semicolon, and then the June billing, and then in the amount section, you list the amount for each separated by semicolon. This is because the owners and general contractors that I work with tell me they want to track these conditional releases. So if you tell them you haven't been paid for May, and they know they just released May, then next month they'll expect May to drop off the form. So this allows them easier tracking to make sure the money is actually flowing down to everybody who should be paid for the job. Our fourth exception is the contract rights. We're not releasing those by this particular form. So then I have the same form for unconditional, tracks very similarly, only putting in the actual payment I received, and now I'm giving my unconditional. So here's our conditional on final. You'll see how it changes. So we no longer, the top is the same kind of people are listed. It tells you what you're releasing and notes the exceptions that are allowed below. Again, the maker of the check, the amount, who's it's going to be payable to. And then exceptions, it's suddenly cut way down. Only one exception that is allowed, not prior progress payments, not retentions. The only exception we can put is if we have disputed claims for extras in the amount of. If we've been paid everything and this is our last conditional and we're just getting our retention, we put 0 here, and they're going to want to see a 0. They're not going to want it left blank. fill it out, we put the 0, we let them know we only have the amount we're looking for on this form, and then we're done. So we list that. If we still have not received progress payments and an owner or general contractor is asking us for your conditional so you can get your retentions, then you need to make it a cumulative conditional. And by that I mean it needs to be the total amount you expect to be paid back here in the amount section. So the amount of the check has to be all your prior progress that you haven't received, all your change orders that you expect to be paid, unless we're going to put them down in the disputed section, and our retentions. If we only put the amount of our retentions on this form, and I had a client who did this several years ago, the general said, I'm going to take all the conditional releases for final payment. I'm going to get the retentions released, and I'll get your prior progress payments released. And my client put in $20,000, even though they were owed $100,000 of prior progress plus the $20,000 in retention. The general contractor took all the money, closed down, disappeared, went to Texas from what I heard. And my client was only allowed to lien the property for $20,000. So they've waived the $100,000. It's just lost. So no longer available to them. So we got to be careful on what amount we put in there. I generally tell people you can do one of two things: put in the total amount, including progress or retention, or tell the general contractor or owner, I can give you the conditional final release once you catch up and pay me all the progress that are outstanding. So in other words, you just don't even give this form until you're ready to put in just the retention billing. So we have some case law under the waiver and releases. The appellate court held that the release is enforceable even if the claimant is not paid. That came out of the Tesco case. Tesco, as a supplier, had received a check for $194,000. The subcontractor asked them to hold it for 30 days. You know, things were a little tight. A few days later, they invoiced for more supplies that had been delivered and gave a conditional release for $50,000 through that through date. The general contractor, the subcontractor that asked them to hold the check, bounced the check, went out of business. The general paid the $50,000 on the conditional release, so now it becomes an unconditional release. So a conditional release plus check, canceled check, equals same as unconditional release. The only condition on that conditional release had been met, the payment had been made, and the court concluded that the conditional release through the through date is valid, even though Tesco had never been paid for that $194,000. Again, I already mentioned this, it's avoidant and enforceable if they try to have you sign something different, or if they try to put in your contract. I review a lot of contracts for contractors and draft them. And especially for out-of-state contractors, I see them often put in the contract that you're, waiving your right to a mechanics lien, you'll agree not to lien the project, all of that. California, that's not enforceable. We had the Moorfield case more recently, though. So it said in 2014, if you're the direct contractor and you agreed to subordinate your mechanics lien to the lender. So this is something direct contractors are often asked to do. Come behind the construction lender and they sign a subordination agreement. This was decided under the old 3262, but it has similar language under the current statute. And the court said that the direct contractor could subordinate to the lender their mechanics lien rights without following one of the statutory forms. This would not be valid for subcontractors because of the way the statute is written. They cannot subordinate to the lender, but the direct contractor, unfortunately, or fortunately, if you're the owner or lender and you need to have the liens subordinated, the direct contractor can do that. So that's it on the release forms. We're going to go through project completion because I've thrown a lot of 30 days, 90 days, 60-day things at you, and you'll have this all in your materials in writing. So the time of completion for California projects, everything runs from completion of the entire project, not from completion of your work. That's only for federal. So we need to know when a project is complete, and probably one of the hardest things we deal with on a daily basis. I get this question, it seems like at least once a week. How do I know if they're done? How do I know when my mechanics lien has to be recorded? That kind of thing. So for a private project, the court says when we have actual completion, meaning no more construction work is going on. We also can look to the occupation and use by the owner. So the owner moved in, the owner is using it for its intended purpose. If we have a cessation of labor for 60 days, then that is equivalent to project completion. We had some of this going on during the COVID situation. I know some projects that completely halted. Basically, the owner said, we're going to stop work until we know everything, what's going to be safe to work, how we're going to go forward. Or maybe they were working. I mean, there's just some projects that people are not seeing a lot of use for today as much, hotels, entertainment venues, that kind of thing, where people are concerned about finishing construction and reopening those venues. So some projects did come to a halt. If there was a cessation of labor for 60 days, and that means everybody stopped working, not you stopped working, but everybody off the job is locked up, closed up, everybody hammers down for 60 days, we have completion even if the project isn't complete. So we have to then go ahead and do our mechanics lien, do our stop payment notice, and do our payment bond claim. Or on a private project, we're going to look to a recording of a notice of completion or notice of cessation. Acceptance by the owner of the project is not part of the test for private projects anymore. If a notice of completion or notice of cessation is recorded and it's a private project of more than 4 units, the owner has to serve that notice of completion or notice of cessation on all the claimants that served a preliminary notice. If they fail to do so, then it's as if no notice of completion was actually recorded. We go back to the 90 days. So on public projects, how do we tell them they're complete? The good thing about public projects, again, as I said, the Freedom of Information Act, they have to share information with you. On a private project, they don't have to tell you anything. You could call the owner all day long and they don't have to talk to you. On a public job, they have to tell you, and they'll have public records. So what we look to for public project completion is acceptance by the owner. And usually that's some public entity, some city council, some school board. And it'll be right in their minutes saying they are accepting the project. And that is deemed completion now. Or we have cessation of labor for 60 days. That's also completion. So in other words, work stop, no one's been doing anything for 60 days. Or again, recording of a notice of completion or notice of cessation. We had the Golden State boring case. The court held that a cessation of labor for more than 30 days. This was under the old statute. It's now 60 days. The claimant hadn't filed their claim timely. It basically just affirmed what the statute says. Work stops for 60 days. You got to pursue your claims. If you don't do so, you lose those claims. So again, cessation of labor for a continuous period of 60 days. After 30 days of the labor being stopped, the owner may record that document I said was called a notice of cessation of labor. Then the time is calculated from 30 days after that. So it's, in other words, 60 days after stopping of the labor, all labor. And once we have that cessation, either by the recording or by no recording, just work stopped, we have then our time starts to tick on the mechanics lien, the stop payment notice, and the payment bond claim. So that's after that 60 days is up, we have 90 more days to do our mechanics lien, or if a notice of cessation is recorded, another 30 days to do our mechanics lien. We have our stop payment notice due to be served within that same period. And our bond claim is again the 6 month plus either the 30 days or the 90 days. If the project restarts after we already had a 60-day cessation of labor, we have to treat it like a new project. So if we're not paid, we still have to do our mechanics lien and all of that, even if we've gone back to work, and we have to treat the going back to work as a whole new project, even if we didn't get a whole new contract. So now we serve a new preliminary notice. We basically split the job into 2 mechanics lien rights, one from when we started back and one for all of our work pre-cessation of labor. So when we have a notice of completion, that triggers our, or the owner has 15 days to record a valid notice of completion. It used to be 10 days under current law. If they don't record it at the right time, it's going to be an invalid notice of completion on its face. We had a case from, you see, 1959, an old case, but it's still, as far as we've seen, the law today that I had a client that had one recorded in January or February, and she just finished her work last week. So clearly a premature notice of completion, it's not going to be valid. It's not going to be effective to do anything. You have to wait until the work is done, and then you have to record it within 15 days of actual completion. So the good thing, the reason the owners do notice of completion is to cut down the time for doing mechanics lien claims. But I don't see many owners actually recording the notice of completion and then serving them on all the claimants that did a preliminary notice. A few more today than when the statute started, but generally they're not. So then we just go from the 90 days of actual completion. So what does that mean? Once we go through all this and we figure out project is complete or project is not complete, then our time starts running. So if I have actual completion with no notice of completion, I have 75 days to do my notice to surety if I didn't do my preliminary notice. Or I have 90 days to serve my mechanics lien, get it recorded and served, or 90 days to serve my stop payment notice. It is not recorded. And then if I have a recorded notice of completion and it got served because it was required to, public entity doesn't have to serve, but it was required to be served, it was properly served and recorded, then I have 15 days to do my notice to surety if I didn't do a prelim. I have 30 days for subcontractors and material suppliers to do a mechanics lien to get it recorded and served, or to do the stop payment notice, same thing, just served. Or if I'm the direct contractor, I get 60 days to do my mechanics lien to get it recorded or to serve my stop payment notice on the construction lender. And don't ask me why the direct contractor gets more time than the subcontractors, because the direct contractor is probably the one who knows more about completion of the project than the subs. But for some reason, they negotiated better when these statutes were first written and they got extra time. I think it was, the thinking was, let's see, get all the sub claims in, and then the general can decide if they want to do their claim of lien. Sorry, I had to take some water so I don't start coughing. I'm healthy, no COVID here. Not that you would care because you're there on the screen. That's why we're doing it this way. But the statutory clock is the statute of limitations. So these are just your statutes we've kind of generally been through. I have forms in the handouts for you on these. No more than 90 days after we record that mechanics lien, we have to file our lawsuit to foreclose. 90 days after the time within which the mechanics liens could be recorded, we have to file suit on our stop payment notice. So it's more time on our stop payment notice. We get 30 plus 90 if we have a notice of completion, or 90 plus 90 to file our lawsuit on that stop payment notice. 5 days after we file our lawsuit on the stop payment notice, remember we have to give that notice of proceedings just so everybody knows we don't have a dead stop payment notice, but we actually filed suit. That'll be something for your attorney to do, but just so that you understand the process and why they would be doing this. when I file a lawsuit to perfect a mechanics lien, I give the notice by recording for the whole world to know that we have pursued the mechanics lien by serving what's called a les pendens, and that is also recorded with the county recorder. And if I have a payment bond claim, I get even more time. I get 6 months after that 30 days for a notice of completion, or 90 days plus 6 months after actual completion to file my suit on that statutory payment bond claim. 1 year after completion of your specific work on the Miller Act bond, and 2 years after the loss to file a complaint on the contractor's license bond. So if those are just some different statutes there. And we had a case in 2016 that went from when the statutory clock starts to run. So you have to make sure you finish your work. So we don't want to prematurely record our mechanics lien unless we don't intend to return to the job. So in other words, we've been fired or we've quit the job if your contract allows you to do that. Generally they don't, but if it did, you stopped work and you said, I'm not returning to this job, I'm done, then we go do our mechanics lien. Or you finish all of your contract work, then we do our mechanics lien. We don't wait until we do pickup work or punch list work. It's a very fine line though, because in the case that was decided in 2016, the owner argued that completion, or actually this is the case that came first, on the completion versus substantial completion. This one actually was of a benefit. They gave the contractors more time. The owner said completion should look to substantial completion, not actual completion. And the court said, no, the statute says actual completion, meaning hammers down. We're not going to extend it by minor punch list work, but if you're still got contract work going on, then that's going to extend the time to record your mechanics lien and to file your lawsuit. So then that's the outside time. When is the latest? We had a case that was decided in 2019 on when it's premature to do your lien. This is what I started to talk about. I thought we were on the precision framing case. This said, don't record your mechanics lien too early. In that case, Precision completed its work, but it had corrective notices from the city with regard to the framing. Precision said, we don't intend to come back. We think the trusses are right. We're disputing this. We're not going to come back and fix this. Recorded their mechanics lien, intended to be done, but as things turned out, they weren't actually done, and they decided after all to go back and repair their work. And it was a major repair of which they were aware before they recorded their mechanics lien, and the court said, so then once they were done, they didn't release that mechanics lien and record a new one. Instead, they relied on that earlier mechanics lien, and the court said, no, too early, you weren't done with your work, it's an invalid mechanics lien. So when do you do your mechanics lien? You don't do it too early, you make sure you're done. You don't do it too late. You don't make sure the whole project is done and been done for a while. So we can't be too early, we can't be too late. We kind of got to hit that sweet spot on recording the mechanics lien, serving the stop payment notice or the payment bond claim. So that's it on the specific lien claims. Under the mechanics lien statutes, we also have the prompt payment penalties. You'll see they're under the 8800, 8802, and 8812 and 8814 of the Civil Code. They were reworded in 2012 like everything was. We changed a bona fide dispute to a good faith dispute. Still pretty much means the same thing, but I think the court understood the good faith dispute language better. So you can not pay someone once you receive the funds. You can hold the money from passing it on if you have a good faith dispute, and you can withhold 150% of the disputed amount. If you are supposed to pay timely and you don't, there's a penalty of 2% per month plus attorney's fees. So that's 24% per year. It's a hefty penalty for not paying timely. They also lowered the time from 10 days to 7 days on the public works. In your materials that I handed out is a California prompt payment statute chart. This is the chart. I know you probably can't read it on your screen unless you have one of those jumbo monitors. But this chart is very helpful because you look down, what type of project did I have? You know, was it public works, private works? Am I the payor? Am I the owner or the direct contractor? Who am I paying to? Am I paying progress or retention? How many days do I have to pay it? And if I don't, what are the penalties for failing to pay timely? For good faith disputes, what I can back charge or hold. There's also a legend with little crosses that says waiver of any provision void. So if it has a cross, basically anything dealing with retention, you cannot waive by your contract. So you cannot waive in advance. I can't say I will receive my retention 60 days after you, general contractor, receive the retention from the owner. It's mandated by law to be this 10 days or 7 days, and it can't be changed by contract. But as to your progress billings, those can be modified by a written agreement. So I can say, general contractor, if you want to pass on the money to me 30 days after you get it from the owner, and I put that in my contract, then it would be binding and enforceable. We had in 2016 where they clarified some of the prompt payment language. Prompt payment only guarantees payment once it's been made. So in that case, the subcontractor claimed that the general contractor didn't pay them the retention within the statutory period. It was quite a bit of money, but the general contractor was in a dispute with the owner on a public works project, and they hadn't been paid. They hadn't been paid the retention for the project. So the court made it very clear that it just means once you receive the money as the general contractor, you have to pass it on. It doesn't require payment before you've actually received the money. So you don't have to advance the money or risk prompt payment penalties. We had in 2015, we had a split in decision between two of our appellate courts, and finally the California Supreme Court came out in the United Riggers case. And in that case, it was, you know, what we like to say that bad facts make bad law, or, you know, the same for good facts making good law. It was really a unique case but thankfully set a good tone. It was a fight between a general contractor and a subcontractor, and the sub had submitted change orders which were disputed. There was no dispute on the retention. The general decided to put pressure on the subcontractor to get them to cave on the change orders, and said, I'm not going to pay your retention until you waive some of these change orders or negotiate them way down. And said, you know, I'll see you in court. Actually wrote that in an email. So basically telling them they're going to have to go to court and wait years to get their money if they didn't do what they wanted. The issue was whether a good faith dispute means you can withhold retention funds when the dispute is about change order funds. And we had that split in authority, and the Supreme Court said, no, this is just basically an attempt to put pressure on the subcontractor to gain an advantage. If your dispute is about the retention funds, which are earned as the project progresses, then you can withhold retention funds. But if your dispute is solely over change orders, then you can only withhold change order amounts up to the 150%, and the retention has to be released. So be careful if you're on the owner general contractor side, you don't hold the money too long. And if you're on the sub and supplier side, it's an advantage to you to have this 2% potential penalty hanging over someone who's holding on to your money. So it's just another claim under the Mechanics Lien statutes. We also had implemented in 2017, not under the Mechanics Lien statute, but under the public contract code, And since this is all about claims, I now included in the advanced class, if you're doing public works, we now have a claims process that is supposed to speed up change order processing by the public entities. I'm not sure that it does, but maybe in some forums, some public entities it has. There's some, the state exempted out some of their public entities, like the transportation, parks and rec for the state. So those are exempted out, but the general contractor can now make a claim either for a request for extension of time or for payment of money. And the public entity only has 45 days from receipt of that claim from the contractor to respond. If no response, the claim is automatically rejected as disputed. And then any undisputed portions must be paid within 60 days. And then unpaid amounts accrue interest. Again, this was to keep the 2 years after the project is done, we're still fighting about change order stuff from going on. So much quicker for the general contractor to force the owner's hand, a public entity, on dealing with the change order claims. Again, if any portion is disputed, it can go then to a settlement, either a mediation under the public contract code, or it could go to an arbitration if it provides for that and then dispute in the contract. You can't waive this claims procedures in advance by the contract. The public entity can't do that. It's allowed for every general contractor. Unfortunately, subcontractors have no direct right to go to the public entity to make their claim. They have to request that the general contractor submit a claim to the public entity and provide reasonable documentation supporting their claim. Within 45 days, the general contractor must notify the subcontractor whether the submitted claim will be sent to the public entity. And if they refuse, then they refuse, and then the dispute can go to mediation or arbitration. But the general could just say, for whatever their reasoning is, they're not going to send it on to the public entity. It could potentially create a claim between the sub and the general for bad faith failure to submit the claim. But the general could just say it didn't have proper documentation, or we didn't know if it was legit, so we weren't going to risk a false claim scenario by submitting the claim for the sub. So it really gave negotiating help for shortening time on change orders to the general, but not necessarily the subcontractors. That is it. We are done. I will answer any questions. So you got a few minutes, put things in the Q&A or the chat box, either is fine. Or before we end this session, go to the chat box and get, if you can find them, the Dropbox link. If you missed it, or you forgot to download it, or for some reason it didn't work, or you couldn't find it in the chat, send me an email to ttate@builderslaw. It's right there on your screen. And I'd be happy to send you the link to all the materials. So there's a lot of materials. It'd be kind of hard to email. I could, if you couldn't do Dropbox for some reason, I could have my staff send you a bunch of successive emails with the materials. But you want to get those materials because it's all these time frames. You don't have to keep track of the 30 days, the 60 days, the 90 days. And you'll have all the outline. It's got more information even than I could possibly cover in 3 hours. Some good reading materials that, you know, when you're bored, you're stuck in the house and you can't leave to go out to dinner. You got something to read to help put you to sleep maybe at night. So any more questions? The question and answer, I see I've answered everything that's there. But again, I said I'll give you a couple minutes to, we're a little bit ahead of schedule, to put any questions, anything you thought I was going to cover and I didn't, or anything I went by too fast. I do talk pretty fast. So something you didn't get, feel free, post it in the Q&A. And now's the time. Now's the time. You got 12 minutes with a lawyer for free. No billing coming out of this. Get your questions answered. Okay, I don't see any questions in the Q&A. So if you don't got a question and you're done, you could just drop off. Okay, thank you everyone for attending. Again, like I said, send me an email if you didn't get something, you didn't want to post it in the Q&As. I'm happy to answer your questions. 6 months from now, if something comes up and you just say, I attended your seminar. And some people call years later and say, I attended one of your seminars. I'm fine with that. I will either talk to you on the phone or send you a short email. I'm happy to make sure that you understand this. I know it's critical to the work that you do. So thank you, everyone. And thank you to the BIA for hosting us this morning. I really appreciate it.